There are several schools of thought out there. Some argue that the Constitution does not vest the Supreme Court with powers to invalidate or expunge any part of the Constitution. The judgment yesterday, they argue, appears that that is what the Supreme Court has done. They ask, what then happens to the provisions of Section 162, which talks about the creation of the states and local government account, if the federal government is going to pay directly to the states, to local governments?
Chamberlain, this battle actually started in, I think in 2004, when the president of the country, President Olusegun Obasanjo, ordered that the funds of local government in Lagos State be confiscated on the ground that the Bola Tinubu administration had created a new local government. Actually, it was another directed at about 4 state government, but it was only Lagos that stood its ground. And the Lagos State government won the case in the Supreme Court, i.e., that the president has no powers to order the confiscation of the statutory allocation of local governments in Lagos State. But the judgment didn't say that state governors shall have the power to seize the money, which has been the case. Again, in 2005, thereabout, the National Assembly made a law for monitoring local government funds in the country by appointing monitoring committees. Again, the state government went to the court. All the state government, the case of Attorney General of Abia State and Attorney General of the Federation. And the Supreme Court said that the federal government had no power to monitor the funds meant for local government because the local government are democratically elected. And so what we now have this time around is that since 1999, money meant for local government have been diverted in the majority of the states in the country. And so this was what informed the decision of the federal government this time around to ask the Supreme Court to intervene. And the Supreme Court has intervened. It is now left for the Nigerian people to actualize the terms of the judgment to the benefit of our people.
Good morning.
And the Constitution has not been violated.
I just need some clarification. That money, does it still go into that joint account?
No, what the Supreme Court is saying, the joint account, the money was not supposed to sit in the joint account. It was supposed to pass through the joint account because in that joint account, if you read Section 162 and 7 of the Constitution, the money given allocated to local government by the state government should also go to the same account. But this time around, the state government do not allocate any money to local government. So what is the purpose of putting that money in that account? Hence, the Supreme Court has said, having regard to both sections, by the combined effect of Section 7 and 162 of the Constitution, local government shall henceforth have their money directly paid to them from the Federation account.
Okay, so that actually brings me to what some of the issues that are being raised by people who are not very happy with this court judgment. One of them is the fact that this now gives the federal government ability to interfere with local governments, pushing the states out. In fact, one of the words that we used was political leverage. If now you know that your funds are coming to you directly from the federal government, the same issue that we said the state governments were doing with local governments, that the federal government will now be that meddlesome. And this, they say, would affect the balance of power, especially in states that are not part of the ruling party. What do you make of this?
No, that will not be possible. Again, as I said, there are 2 judgments. Attorney General of Lagos State and Attorney General of Abia State against the federal government, where the Supreme Court ruled that the federal government cannot touch the money meant for local governments in Nigeria. So what is going to happen now? It's not that the federal government would decide what should go to a local government. The nexus between the federal government and local governments now It's not about bypassing local government. It is that money meant for local government in the federation account shall be paid to them directly. That's all. It's not that the federal government will have the power to touch the money, to seize the money, or divert the money.
If the issue is this local government accessing the money, as you will understand it, so what is wrong with this option where since the joint account still exists, if money goes into that account and then the law says the states, LGs have to receive those funds directly. So if it still goes into that account and then the LGs can access that account directly, in the event where a state tries to give any local government person directive and say, well, this money is here, do this, or you won't get the money, a local government chairman by this judgment can say no, because they know that if the states don't allow those funds come through, the funds can access, the FG can intervene and pay them that fund directly. This, some argue, will ensure that Section 162, which creates a joint account, doesn't appear to have been expunged or invalidated. What do you think about this perspective?
And may be correct, partially, but when you look at Section 162, it simply says 162 subsection 6 creates a joint state-local government account. But 7 says, once the money gets to that account, it shall be paid to the local government. It does not say the money will be kept or diverted or spent from at the joint account level. It said it shall go to the local government. And what the Supreme Court has said, in view of the abundant evidence that this money is being diverted from the joint state-local government account, let it go to the local governments directly, in line with the letter and spirit of Section 7 and 162 of the Constitution.